those that are joining, talk about the probate court, estate planning, and the probate process. And we're here at the courthouse. Let me see if I can get our PowerPoint up, and hopefully you can all see that. And we'll run through that. That's me. We normally do this at the Public Service Building in North Charleston, here at the courthouse. And these are our judges. It's myself, Judge Kirshner, Curry, and Cooten. So all that K sound, Condon, Kirshner, Curry, and Cooten. I should have told you, there's two rules as far as jokes. Only the judge tells the jokes, and no matter how bad the jokes are, I need you to laugh, but I can't hear you unless you just send me a little email telling me that you thought the joke was funny or bad. Anyway, it's difficult times, strange times. My son's doing school online, which is very difficult. We're very proud of Judge Tamara Curry, who just served as our president of the National College of Probate Judges. She was the first African-American president of the National College of Probate Judges. Many of you are from out of state, but this is a nationwide organization that deals just with probate matters. And she just concluded serving as president of that organization. We're located down here at the Four Corners of Law. You'll see the church there, which is the highest law. You'll see the mayor's office on the lower left. Federal court is up on the top right, and our historic courthouse is located on the bottom right there, almost like a Charleston single family home. I'm located on that third floor of that estate division, but also today I'm coming to you from the Judicial Center, which is down on the bottom right that you will see. And I indicated earlier, we normally do these webinars or seminars in person, and usually do it at the Lonnie Hamilton Public Services Building. But coming you for our first webinar, so be nice on us. This is the first time we're doing it, and we're learning. And I must thank Jamie Robinson, who's done a tremendous job in setting this all up. And with her help, we're able to go live here today. This is how the historic courthouse looked back then, and this is how it is today. It was our state capital here in Charleston before it moved to Columbia. And again, the estate division, if you're probating an estate, you'll go to this building that's on the corner of Broad and Meeting Street, and the estate division's up on the third floor. The architect of that building was an Irishman by the name of James Hoban. He did our courthouse, and then also when George Washington visited our city in 1790s, he liked the work that Hoban had done and had him bid on some other buildings, and he beat up the likes of Thomas Jefferson to do the White House, the president's house. So when you see the White House on TV, it's a Charleston architect that modeled it after our historic courthouse. And then in the portrait on the right, you'll see the Leinster House, which is a national Parliament building in Dublin. Back then it was flattery to copy someone else's work, and that's what Hoban did. If you looked at the Leinster House, the White House, and our courthouse, you'll see the similarities. A couple years ago, we were over in Kilkenny dedicating this marker. That's me there in the middle to James Hoban. My son is over there on the left in the plaid pants. We didn't get our luggage, so we had to buy some pants, and he bought those. And he's not quite sure what to do with that young Irish girl that's next to him to his right. But trying to give Hoban recognition for doing our historic courthouse and also the White House. A little bit of test here today. We're all wanting basketball to come back. You may have seen the 30 on 30 on Michael Jordan. If y'all can text in, who can guess what's the highest basketball court in the land? Again, as I told you, you have to laugh at all the judges' jokes, no matter how bad they are. Anyway, I'm 2 for 2 in this basketball court. And if you just thought about it for a second, it's not in Denver, Colorado, but it's It's at the United States Supreme Court. If you go above the U.S. Supreme Court, you'll see a basketball court. You can't shoot while they're having arguments. You can only do it when they're not having arguments, because you hear the balls dribbling down below. But I made 2 shots and I retired. So that's the highest basketball court in the land. And I kid my son, who's a big LeBron fan, that not even LeBron or Michael Jordan have scored here. This was my mentor, Morris Rosen, Southern gentleman that practiced law into his 90s. He was always kind and nice to everyone, no matter their stature in life. And always try to model myself after him. He was a father figure to me in the law. Today's topics, generally we talk about estate planning. I'll briefly cover that. We'll briefly cover the probate court, mention our problem-solving courts, but then we'll stop over at estate administration and go through a typical estate procedure. And in South Carolina, we have 3 ways. We have a summary proceeding, normal administration, and contested cases. But we'll go through estate administration primarily today. But I do want to start with everyone considering their estate planning and considering their needs. It's very important that we all, particularly in times like this, that we make sure we have our will updated. And Jamie's been kind enough to send you all the different documents considered for estate planning. I've got a slide here that I'll show you shortly, but I would recommend and strongly recommend that you use an attorney in doing your estate planning. Do not do it yourself, and that's over all of our documents. So make sure you use an attorney in doing your estate planning. And these are the 10 documents that I'll briefly discuss. The first is the last will and testament with a trust. Most South Carolinians can use a trust inside their will to protect those that cannot handle the money or are incapacitated either by age or by some other incapacity. If you do not have a will, the South Carolina legislature has written you a will called the intestacy statute, and it'll go to, your property would go according to your family tree. There are many benefits of having a will. A will allows you to decide who receives your property and when. You can decide who the personal representative is. It could be, used to be called executor, executrix. In a will, if you have a named personal representative, you don't have to post a bond, which we'll talk about later in the estate administration process. A will is very important, even if you do a revocable living trust. If you put all your assets in a revocable living trust, the attorney will always recommend a will, a pour-over will, that pours over anything you haven't put in your trust into your revocable living trust. But as we see here in South Carolina, the probate fees are nominal compared to other states. So most South Carolinians are fine with a trust inside a will rather than doing the revocable trust with a pour-over will. But I would have you sit down with your attorney and make your choice as to what's best in your situation. If you own property in a number of different counties or states, then it may be advisable to have that revocable living trust. Another way to manage property during your lifetime is a durable power of attorney. And we'll talk about 2 of them, and you should have both of them. And they can save you money and allow your assets and your healthcare decisions to be made if you're unable to make those decisions. The first is a financial or business durable power of attorney. This allows you to name a layperson, a spouse, a friend, a sibling, or a child as your agent to make your financial decisions. A financial power of attorney has to be recorded at a Register of Deeds office to be effective. You'll see many different powers of attorney, some just to close a real estate transaction, some very broad. Again, get with your attorney. The reason it's called a durable power of attorney is that it allows the principal to act, allows the agent to act even if the principal is incapacitated. Under strict agency law, and I don't want to make you lawyers here today, but just try to explain this concept. Under agency law, if the principal is incapacitated under strict agency law, then the agent cannot act. And that's generally when you want the agent to act. So we have what we call a durable power of attorney. Durable meaning that agent can still act even if the principal is incapacitated. And there'll be magic language. And by state statute, all powers of attorney are now durable. Again, the financial power of attorney is unique like the will. It fits your situation. And then you name an agent and you'll name an alternate. Just like in your will, you'll name takers of your property and then alternate takers, because people don't always die in the order you think they are. And even with your fiduciaries, your trustee, your personal representative, your agent under the power of attorney, someone may predecease you, so you always want to have an alternate there. The next document, and these documents are provided by Ms. Robinson in the email she sent to you, is the healthcare power of attorney. It is what we call a statutory document, meaning it's the same for everybody in South Carolina. And this allows our healthcare workers to see the same document when it comes in. It's not unique like a will or financial power of attorney where you have to read each one because each one could be different. The healthcare power of attorney is right out of our state statute, and it's the same for everybody in the state. It does have flexibility and allows you to make decisions or choices that fit your need. You can call for maximum healthcare treatment. You can have it withdrawal treatment. You can name an agent. You can name an alternate. It addresses organ donation. It addresses getting medical records that may be covered by HIPAA. Again, the healthcare power of attorney does not have to be recorded. You would give this to your primary care physician and also let your family members know where your healthcare power of attorney is. The fourth document is a declaration of desire for natural death, also known as a living will. It gets confused with the living trust, which deals with property. A living will deals with end of life decisions. And we've seen a number of these cases around the country. Most recent, probably Terry Schiavo, but before that, Karen Ann Quinlan. And even before that, there was a young lady named Nancy Cruzan who did not want to be kept alive on life support if she was in a vegetative state. But there's no law in place allowing that declaration to be made. That case out of the state of Missouri went all the way up to our U.S. Supreme Court. And the court said, yeah, you can withdraw life support, but it's such a step you're taking, it needs to be in writing. So there's safeguards there. And again, the declaration of desire for natural death, again, there's no right or wrong answer here. It's whatever you desire. But if you desire a natural death, then this declaration needs to be in writing. You'll see that 2 doctors have to sign off on it. It is not recorded. It's given to your primary healthcare provider. Again, it's called a living will, not to be confused with the living trust. It also is a statutory document, and you can see that it has flexibility in it where you can ask for maximum care or withdrawal of care. You can also name an agent to enforce the document, to enforce your wishes, or a document allows you to withdraw have an agent withdraw that declaration. The fifth that I mentioned here, revocable living trust. Again, this is a document that allows you to manage your property during your lifetime, and at death, it acts as a will substitute. I should have mentioned with the financial power of attorney, the beauty of having that document or trust is that you avoid the conservatorship. If you do no planning and you become incapacitated and assets that you own need to be managed, then you will have to come to probate court here and get what's called a conservator appointed. And that process can cost some money. Generally, you have an attorney bring the action. by law, we have to appoint an attorney for the alleged incapacitated person. We have to appoint a guardian ad litem to look after the best interest and an examiner. And when you get all those professionals involved, you can see that it will cost some money to do that. Excuse me. Sorry, make sure I wanted to sneeze properly and not on anyone, even though we're doing this virtually. Anyway, the financial power of attorney avoids the conservatorship. The healthcare power of attorney avoids the guardianship. Probate court has jurisdiction over adult guardianship and minor and adult conservatorships. So if you don't have the healthcare power of attorney, you'll be at the court here getting a guardianship appointed. Same process as the conservatorship, attorney bringing the action on behalf of a family member. We've got an incapacitated adult. We have to appoint an attorney to protect their legal rights. And then we have to appoint a guardian ad litem to look after their best interest. And then we have an examiner. All of that process can cost several thousands of dollars, hopefully less than that, but that's what it can cost. But if you simply went to an attorney and had your estate planning, you can save yourself and your family money. I should also mention with any estate planning, if you've got everything you ever wanted for Mother's Day or Father's Day or birthday, you can ask your children to pay for your estate planning. The attorney's duty is still to you, even though it's paid for by another person. So that's a gift that we always recommend. Maybe consider if you've got more golf shirts or dresses or anything else that you need, consider having your children pay for your estate planning. The next document, we get into making decisions. I mentioned revocable living trust, and we'll see some. You can name living trust whatever you like. It acts as a way to manage your property during your life, and then at death, it allows you to manage your property and decide who receives what when. Even if you do a revocable living trust, as I mentioned, the attorney will recommend what we call a pour-over will. Pour-over will basically says anything I haven't put in my living trust, I now put it into my trust at my death here. The reason for that is many times we put everything in our revocable living trust, and then we buy another asset and don't title it in the name of the living trust, and we've got to probate that one asset and get it over into the trust. So that's what the pour-over will does. Again, one of the advantages of the living trust is it allows you to manage your property during your lifetime, and at death it acts as a will substitute. The downside is that the administrative cost and the cost for a revocable living trust may exceed the benefit that you could have gotten by just having a last will and testament with a trust inside of it. For any trust at death, as far as children are concerned, we would recommend that you give them, say, 1/3 at 25, 1/3 at 30, and 1/3 at, say, 35, so that they learn along the way. Of course, you would have invasion powers in there to invade for healthcare or medical decisions or medical emergencies that may occur, or to invade for education for them to go to medical school or law school or graduate school. But again, you want to document where your trustee can say yes if they know your wishes. They should know your wishes and what you want, and they can say no. An example would be, yes, we'll pay for your college education, but no, you don't get to live in the penthouse in downtown Charleston and drive the convertible Jaguar. You've got to get a reasonable car and a reasonable expensive apartment. And that's what you would want in your trusts. The most restrictive trust I think I've seen was a child couldn't receive the money until age 65. And why 65? I think those parents were counting on Social Security to kick in for this person that was a spendthrift. But 65 was the age that they picked. Other documents that I'd like to talk about start with decisions at end of life. One that is a national document that you can download. I think it's either $3 or $5, and I think we provided it in the materials here. But if you Google 5 wishes, this is a nonprofit out of Tampa, Florida. They just want Americans to talk about end of life and the dying process because most Americans do not talk about this and do their planning. But if you go to their website, the 5 wishes is sort of a combination healthcare power of attorney, living will, and a DNR, which I'll talk about shortly. But it allows you to put in layman terms what you desire with your 5 wishes at the end of life, how you want to be treated, the comfort care, how comfortable you want to be when you're dying, and how you want people to treat you, and what you want your loved ones to know. And you'll see the document that was provided. We've got a sample, but if you go to their nonprofit, you can see the 5 wishes. Again, it's a very good planning. It's a very good tool, and it's a national, it's accepted in most states. The DNR, which is the Do Not Resuscitate Order, not to be confused with the Department of Natural Resources. It's an end-of-life decision-making tool that allows you to have life support withdrawn in a case where your survival is not in question. I lost a brother a couple of years ago to cancer. He had a DNR. He knew he was going to pass from the cancer, so he executed a DNR in case the cancer was going to take him this week. In case he had a heart attack and he was going to pass, say today, when he knew the cancer was going to take him like next week. So it's another planning opportunity. It is an order and has to be signed by your doctor. Along those same lines, we've got the physician's order for life-sustaining treatment, also known as a PULSE, and we're piloting this over at Roper St. Francis with cancer patients. This is an example of it. It's generally a pink document that allows you to make decisions like a DNR, 5 wishes, declaration of desire for natural death, sort of all combined in one. As you can see, all of this has moved from, say, the doctor's office to the lawyer's office. And so it's very important that if you do these documents, that they are consistent. And again, there's no right or wrong answer here. It's whatever you desire. But the PULSE document, some other states will call it a MOLST, which is a medical order for life-sustaining treatment. These started out in the West Coast around Oregon, but you'll see these documents now accepted universally in about every state. Another document, I'll show you a slide later, is organ donation. We should all consider organ donation one way to help others. The founder of this in South Carolina was a Dr. McManus, and I'll show you a slide here shortly where you can download forms for organ donation. If you have questions, I'll try to answer those, but I know it's hard with me talking and then checking the different emails as they come in. The next document is considered as a safe cremation law. Some of y'all may have watched the 30 and 30 last night, if not about the Bulls. My son, I tell him that's the greatest basketball player ever. He's a big LeBron fan, but he was glad to watch Michael Jordan last night. Next to Michael here is his dad, James Jordan. Unfortunately, James Jordan was murdered in North Carolina. His body was dumped in a rural county in South Carolina. That rural county did not have space to keep bodies, so they took a dental mold and then cremated James Jordan without realizing it was James Jordan. And after a national search led by Michael Jordan looking for his dad, they realized that they had cremated Michael Jordan's dad, and that the state had no cremation law. And so our state legislature, many state legislatures stepped in and passed the safe cremation law. In many states, and in our states, it's known as the James Jordan law. And the importance here is that if you want cremation, and more families are choosing cremation, maybe 60 or 70% are choosing cremation, you're required to do a pre-need authorization with your funeral home director or put it in your will. Or after death, all of your family has to agree on cremation, or they need to come to the probate court to get approval. But if it's something you desire, if you want cremation, go ahead and get with your funeral home director and or your attorney and put it in your documents. Otherwise, it may not, after your death, all the family has to agree. And then sometimes we can't locate all the family. In the law, we have to give what's known as due process. We have to give them time to be heard. So by the time we do all of that, it may be longer than you'd want to have the final services for yourself or your loved one. So anyway, consider a pre-need authorization, again, with your funeral home director, or get with your attorney and put it in the will. I'll skip that one. If you want to help others, we've got what's called the Coastal Community Foundation, and they can help you with the administrative cost if you want to help others in our community. And all communities have coastal community foundations, all hospitals, universities, any type of charitable organization have these foundations that can take the administrative cost off you and allow whatever you're going to give go directly to benefit those individuals. We had a devise here once for about $50,000 that was to help high school students in Charleston County go to college. By the time they looked at getting an attorney, tax attorney, a CPA, getting it qualified with the South Carolina Tax Commission and the IRS, they're going to use up a lot of that $50,000. So what they decided to do was just go to the Coastal Community Foundation, and at no administrative cost, able to set up that charitable devise. So consider the Coastal Community Foundation. Your church, your university, or any charitable organization can help you in this regard. If you have heirs property, the Center for Heirs Property is a wonderful organization to help you get clear title to the property. Heirs property is property that's been in the family for years. There has not been any probate of the estates. People have been living on the property, paying the taxes, and so, but they're not sure who has clear title to it. And the Center for Heirs Property can help you there. The Reverend Clemente Pinckney, before he passed, he's a state senator, was very instrumental in getting the right of first refusal passed that allows heirs on their property to buy out other heirs before the property was sold, say to a developer or someone that was not interested in living in the property. Anyway, the Center for Heirs Property also does will clinics and will help you probate your estate. They were just for Charleston County, but they're now for the entire coastal South Carolina, and you'll find them very beneficial. They're located west of the Ashley. If you're looking for an attorney, one way to choose an attorney is to look at this service called Martindale-Hubbell. And what Martindale-Hubbell does is it ranks attorneys, it gives them peer ratings based on their area of the law that they practice in, based on ratings from other attorneys. It's a free service, and you can locate attorneys in by geographical area and by their specialty. I would strongly recommend, if you're looking at getting an attorney, and everyone should, for their estate planning, is that you look at Martindale-Hubbell. Again, the other way to get an attorney is to talk like you do with family and friends, is to get help from your friends and family, like when you're choosing a doctor or a dentist. You ask them who they would recommend, but you want to get somebody that practices in this area. If you cannot afford an attorney, we've got a number of organizations that can help you. The first is the Charleston Pro Bono Legal Services. You'll see their website there. Another is the South Carolina Legal Services. Some of these have I guess, parameters before you qualify. They may check your income or your assets before they do, but many provide legal services at no cost. Charleston Legal Access is the one that charges on a sliding scale. Again, this is organ donation. I think I mentioned this. Dr. McManus started this organization here in South Carolina. You can download on their website free of charge the different forms if organ donation is something you desire to do. And then we always recommend that you take a ski vacation. And if you skip ahead on the slide, you'll see that the ski vacation means that we want you to enjoy whichever you worked hard to obtain. And so that means spending the kids' inheritance. And it may not be taking a trip. Can't take a trip today anyway, but you can maybe helping others. Okay. Because we see many people pass away and not have done the things that they thought about doing. We never know when God's going to call us. And again, if you want to help others, take a trip, maybe help somebody that's struggling these days, a neighbor, family member. Let's do it in our lifetime so that they get the benefit. Uh-oh. Another thing that you can consider is under our Uniform Trust Code here in South Carolina is that you can leave your assets to your pet. And I always jokingly tell seniors that if your children and grandchildren are not treating you well, you can leave it to your dog or your cat or whatever pet you have. We had 2 dogs here in Charleston County that got close to $900,000 in trust. They couldn't be kept outside on a chain. Any surgery was down at Auburn University, I guess, which is probably the best vet school in the country. And then we had another dog out on Kiowa Island that got a house. I know those individuals loved their animals, loved their pet, but I also jokingly say that the children did not treat them well. So if your kids, you can jokingly tell them they better treat you well, or you leave it to the dog or the cat. Again, we're located in 2 buildings down here. We do not want a 7-story building. And Jamie will have to change our slide there because we don't know. I'm not sure if the people on the right are social distancing. Didn't think about that on the slide today. But anyway, the estate division's on the 3rd floor of the historic courthouse on the left. I'm located on the 4th floor to the right there at that new judicial complex. And this is an organizational chart for the court. If you're probating an estate, let's look at the left side. We've got 1 clerk of court, Allison Atwood, the supervisor, and coordinates litigation. And then you'll see 5 estate clerks. And you'll see it's important to see that each of those has certain cases, and we do it by the ending number. In my old CPA days, I use these numbers. And it equalizes the work. So I've got 5 estate clerks. We got 10 possible numbers. So Robin has all cases ending in 0 and 5. Sharon 1 and 6. Jamie that coordinated today is 2 and 7. Talisha 3 and 8, and Teresa 4 and 9. So you'll see that 1 estate clerk will help you from beginning to end. And we found that this is best for families to have that continuity. So they'll help you with the probate process from beginning to end. If one is out either sick or on vacation, the others can help you also. And then Tina Grooms down there is our customer service rep. They're located again in the historic courthouse on the 3rd floor. Over in the building here at the Judicial Center, Regina LeBlanc is our clerk of court there. We've got 2 commitment clerks, and I'll talk about commitments shortly. And then we have 3 guardianships and conservatorship clerks. Again, we want to avoid the guardianship and conservatorship by our estate planning by doing that durable power of attorney for business or having that trust or having that healthcare power of attorney. And then I'll mention we've got 4 problem-solving courts there. And then a happy side, we do marriage licenses. And you'll see those on the top right. And then we've got court staff. I've got one law clerk, James Ward, helping me here today. And Josh down there, the other law clerk's helping me from home. But we have everybody working from home except myself and one law clerk. And they're all looking to return. If you need contact information, you'll see that on this slide here. If you need to get in touch with someone, you can call them directly or you can email them. They're all checking their voicemail, and some even have it forwarded to their personal phones. Again, you can see sort of what we do. On the estate side, we've got about 3,500 open estates. We do about 2,000 of those a year. Guardianship and conservatorship, about 1,000 open cases. Commitments, we do about 1,800 a year. And in marriage licenses, we do about 5,000. If you have anybody that is looking to get married, we've got my law clerk, James Ward, came up with this acronym, the LOVE site here, which is live online virtual e-marriage applications. And there's a way to apply for marriage applications, even if you can't come in, because we're not open, but we're only open to receive filings, and that's from 10 to 2. But you can apply for your marriage license online, and we have this virtual application. Who's getting married these days in Charleston County, or who has gotten married? You may recognize him. Dr. Gupta has been all over the news. He married a Charleston girl. I even ran into him one summer out at Folly Beach, but you've seen him on the news. Reese Witherspoon, Ryan Philippe, even though I think they also visited family court, but they did get married here. Blake Lively and Ryan Reynolds got married over in Boone Hall. And I know we just lost the owner of Boone Hall, and we're very appreciative of him donating or keeping his property in trust so that it's not developed into residential property. Tara Pinsky and Todd, I think they live out on Kiowa. They got married here. If we got any foodies, everybody's probably eating these days. They got married here about a year or so ago. Civil commitments, this is the other side. The involuntary commitments for alcohol and drugs or mental illness. We do about 1,800 of these a year. We're doing these currently virtually, but we generally would visit MUSC, Palmetto, and the VA and do these hearings at those facilities. It's easier for a judge and a clerk to travel than to have our citizens come over to the court and be transported here. We are doing these virtually. Again, this is involuntary commitment. If we've got a family member and drugs and alcohol, mental illness affects all of our families, it allows us to get them care if they won't go get the care themselves. And so this is this process to make sure that they're getting care. This is not a criminal matter. It's a civil matter, just trying to make sure that they get the care, the treatment that they need for drugs and alcohol or mental illness. Some that have come through, you may remember Duncan Proctor. We almost had a Sandy Hook with another commitment patient, Alice Bolin. And then what else we've added are some problem-solving courts, and I'll just run through these, just trying to keep people out of jail, out of prison, and make them productive citizens. And we use sanctions and incentives, not to punish, but to change behavior. And it's a team approach where we meet in a staffing session with all the different agencies, and then we go to court like parents with one unified front. And we're meeting now currently virtually, and just trying to keep people out of jail, out of prison, and make them productive citizens. Adult drug court came from Miami. Judge Goldstein was a Brooklyn cop and lawyer. He started the first one down there in the 80s. Mental health court came from Seattle. Veterans court, Judge Cooten that you saw on our team is a Marine veteran. He heads that up. But Judge Russell here in Buffalo started the first Veterans Court. And I'll show you this one slide. All of our individuals in drug court are not the smartest. Brian here broke into, guess which house? He broke into Chief Mullen's house. Fortunately, Chief Mullen was not home, but Brian and the chief were the chief was very supportive of the program, allowed Brian to enter our program. And here he is on his commencement, on his graduation, giving the chief a check for the restitution for the things that he stole from the chief and his wife. But it's very powerful if you've ever seen one of these commencements, trying to give people their lives back. They're ravaged by alcohol and drugs. Opiates here in our community are taking many lives as we speak. We're doing some other things. We do this monitoring program with the Charleston School of Law, our county and Phoenix with two that were selected. We train visitors at the law school to go check on our seniors, their wellness checks to make sure that they're okay. And then we're working with the National Center for State Courts to check on our conservatorships. We're doing that with Wayne County in Michigan, Detroit there. Trust and Estates, who's coming through, just some other examples. We lost the Charleston 9. We want to make sure all of our first responders have their will up to date and their estate planning up to date. And I'm just asking you to get your estate planning up to date. Many of these first responders, it was considered bad luck to do this. And they're the ones running into these burning buildings while we're running out. I went to school with Randy and Billy Hutchinson. This was a tragedy, but we're trying to change and make sure that our first responders all have their estate planning and wills all up to date. Unfortunately, we lost the Emanuel 9. They did teach us that love conquers hate. There's no violence in Charleston. And these families are very powerful. The estate planning workshop that I'm about to start here shortly is the same thing that I did for them about a week after this tragedy. I didn't meet them at the church. We met separately at the library there. But they were very powerful families, again, showing us that love conquers hate. This family here had to trust and had to have it changed, but the Matthews family is originally from Charleston, probably NFL's first family. And I know we've got the NFL draft coming up on Thursday, which will give us some sports. For our golfers out there, I know that's coming back in June. Pickard actually won the Masters. But we had a will interpretation case here in Charleston County. For baseball players, he led you through a World Series. He didn't sign many documents. He did sign his will. The residuary beneficiary wanted the original back from the court because to a baseball collector, his signature on there was worth about $75,000. The Supreme Court said, no, once you file a document with the court, it stays with the court. So if you're famous out there, and you file your document with the court, and it stays with the court. Countess started Spillane, a very large estate, and benefited our community greatly. I mentioned earlier about you can take care of your dog or your cat, and Ms. Helmsley did that in New York. And you can name your revocable trust anything. James Brown named his the I Feel Good Trust, and that's still in some litigation over in Aiken County. Let's talk about estate administration, and we'll walk through the process there. Again, the first part of that was to make sure that you get your own estate planning done. And then when we get to the probate process, when someone dies, we've got basically 3 ways to do that here. And you'll see we've got what's called a summary proceeding. That's under $25,000, no real estate. You can open and close the estate 30 days after a person has passed. And then number 2, we've got normal administration, which generally takes 9 or 10 months as indicated there. Our state has chosen a creditor's period of 8 months. Some states are 4 months, some states are a year. We're kind of in the middle of 8 months. So it takes 9 or 10 months to probate the typical estate. And then contested cases, fewer cases, but notice in hearings each step of the way takes up more of the judge's time. Again, we've got a version of what's called the Uniform Probate Code. And in this Uniform Probate Code, there's a concept of giving notice to everyone. And if no one objects, then it goes through administratively. So you should have a file there. And if you can flip to that file, we'll walk through normal administration. And let me see if I can get off of here and not lose you. And hopefully you now see this. This is a typical index that we've given you. Normally I would have you at the courthouse here, and it's easier just to flip the pages, but we'll have to go through this probate process. Again, there's 3 ways to probate the estate. There's that summary proceeding under $25,000, no real estate. And many times we see individuals with a lot of assets have to use that because when they did the revocable living trust, they forgot to put one asset in that trust. So they used a pour over will to get that asset into the trust, and they can use the summary proceeding. Primarily it's used for someone that passes, has a car, a boat, one asset or a bank account, and we use that summary proceeding. And then the summary proceeding, we're looking for some of the same documents you'll see on this estate index. We need a death certificate, a will if there's one, this application that you'll complete, which we'll see here shortly. So if we look at this estate index, this is a typical estate file. We've got index numbers which correspond to page numbers on the bottom of the forms that go behind it. So we're going to start up with a death certificate. We'd bring to the court the will. A codicil is just an amendment to the will. We had that. And then this application / petition. That's generally how you would start the process. And let me make sure. And I'm having a hard time accessing, if you're sending me an email, I'm having a hard time accessing those. This is my first time doing it, so have patience. And once I run through this, I'll come back to all the different questions. So we need a few concepts we need to learn. I mentioned the first one is giving notice to what we call interested persons. And if no one objects, then it goes through administratively. And interested persons are individuals that are named in the will called Devosees, and those that would take, if there's not a will, called heirs. And then the third group are what we call creditors, and we give them notice through a paper publication. What I'd like to do is just walk through each of these documents and then make comments on them. Of course, a typical file is built from the bottom up. So the death certificate would be, that's on page 1. Let me go all the way to that. And this is a typical death certificate. And you'll see that we do need proof of death. Years ago, we would take an obituary or a newspaper article. There's another theme running through the court that most laws are written not for those that will obey them, but for those that will disobey them. We had a couple cases here where so-and-so, a newspaper article, we were out fishing offshore, so-and-so fell all overboard, we couldn't find them. We need to open their estate and get the $1 million life insurance policy. Well, lo and behold, the people are found alive in the next county by the FBI, and it was all a big fraud. And so we have to have some proof of death. A death certificate is the most common. If you do have an accident, there is a way to prove someone's deceased, and we've had a number of these. Let me make sure. As my technical help, there we go. Can y'all see that now? Well, I'm sorry if we went through a page or there too. I had it on my screen, but not on your screen. But hopefully you can see the death certificate now. In fact, if we need, we can go back. Let's go back to the beginning here. and you'll see this estate index. I don't think we were looking at this to begin with, and I apologize. You'll see estate index, estate of Lawrence Michael Joseph. We got a case number 2014 would be the year of death. ES means it's an estate. 10 is the county, and 10 is Charleston County. You'll see that in your state tax return. And then 321 is the numerical number for the year. And then we've got a description of each of the items we have there. We've got a date, and then we've got an index number. As I was indicating, that index number is generally the page number on the bottom of each of the documents you have here. Because normally I'd give you a file like this, and we would run through each of the pages. But we're trying to do this virtually, so I appreciate your patience here today. And again, the probate process, this is the normal administration. It's an informal process. It's administrative, in fact. You do everything, filing the documents. If no one objects or there's no issues, and most of our cases are handled this way, the court just makes sure that the notices are given to interested persons at the beginning and at the end. If no one objects, then it goes through administratively, and we'll see how that's done. We were talking about this first document, the death certificate. As indicated, we need proof of death. And if they don't have a body, then we can do a hearing and someone can be declared deceased. We had 2 boys drowned out at Folly Beach. They found the body of one, not the other. We held a hearing about the search that they'd done, the fact that there were 2 boys out there, they found one, not the other. They were able to declare the other one deceased. More recently in the fall there, we had a plane crash off of our coast. We had the reports from the FAA, and then we had a Coast Guard report. And the only thing they found was an oil slick. So if you have documentation and evidence, then someone can be declared deceased on the day of that accident. The other way is if a person goes missing for a period of time. Most state statutes, it's now 5 years. If you're missing for a period of time, then a family can come in and have you declared deceased. And they'll do that by a formal action. And they'll bring evidence or proof that someone has not been heard from for 5 years, and they normally would have been heard from. They normally would send Mother's Day or Father's Day cards, Christmas cards, give presents on birthdays and Christmas or any other religious holidays. And there's proof that that has not been done. So the family would come in and testify that that has occurred. We had one here in Charleston County. The man went up to, hopped on a plane, went to Atlantic City, and was never heard from, just one of those unsolved murders. And the family was able to come in after that period of time and have him declared deceased. You'll look on the death certificate, it'll actually have a cause of death. If you don't want that disclosed on the public record, most courts will take the top part of the death certificate. If someone died of suicide or AIDS or some other reason you don't want to disclose all that, the courts generally will work with you. And I would mention, we have the ability to scan all of these estate documents, put them online, put them on the internet. We've made a conscious choice not to do that, to try to protect everyone's privacy and not have you bombarded by salespeople when they see that you have a large inheritance or devise coming to you. So we made that choice. There is information on the web. Generally shows that the estate is open, who the personal representative is, who the attorney is, and what creditors' claims have been filed. We have some information, but not all. If you die with a will, and this is a sample will that we had handed out earlier, it's called dying testate, meaning that you've got a will and we're going to follow that will. If you die without a will, it's called intestacy, and then that way the state legislature has written your will. And I mentioned that earlier, it generally will go according to your family tree. If there's just a surviving spouse, then it all goes to surviving spouse. If there's a surviving spouse and children, surviving spouse gets 50%, and the surviving children share the other 50%. But it's very important, particularly for our young professionals, to have a will, because many times we see a young professional pass, and then the house is ended up owned by the surviving spouse and the minor children. So very important to do your estate planning. One other concept that, a couple concepts that we'll talk about. The first starts with this application that you'll see here. This is what you present to the court to open the estate. If we look at this document, we've got form documents for everything in probate court, but we try to have some flexibility with it. If it's an informal process, then we check these left boxes under application for informal, probate of a will, or appointment. If it was a formal action where we had notice and hearing, that'd be the right side, petition for formal probate. You'll see some information we would get from the death certificate about the decedent, but the concept I want to talk to you about is under 4A and 4B. If you're named in a will, you're known as a devosee. The old term bequest meant personal property, a devise meant real property. Under the Uniform Probate Code, they use one term, devise. So devosees are those that take personal or real property under the will. 4B are people that take if there's not a will. If the decedent left no will, then these individuals would take. In the example here, I've got dad passing, survived by mom and 4 kids. Under the will, 2 of the kids take, Lawrence and Joanne, and then 2 do not take, this Marion and Raymond. But they're all listed here. And the importance of this is that we have to give notice to both the heirs and devosees. And if you think of this logically, who could complain and actually receive property if the will was overturned? If Marion and Raymond challenged the will and they were successful, then under this intestacy statute, they would share in dad's estate. So they have to be given notice that a probate is going on. And now people are spread across the country, across the world, and they may not know a loved one has passed. So we have to give them notice. And we do that by this form. I'm going to move over this way, see if I can find it for us. Here it is, number 22, information to heirs and devosees. So in this case here, our personal representative, mom, has to give this document to both those named in the will, devosees, those 2 kids, and the 2 kids that would take if there's not a will, the heirs. And again, think about those that could challenge the probate would be those that would take. And if the 2 that were not receiving anything under the will were successful, then they would take. And we let the court know that we've done this by submitting an affidavit or proof of delivery. So in this case here on this document, page 23, mom as personal representative is letting the court know that she's given notice to 4 individuals, and those are the 4 children, the 2 devosees, and then the 2 potential heirs. And this requirement is 30 days after your appointment as personal representative, you're required to give notice to heirs and devosees through this information to heirs and devosees. Many attorneys, when they send out this form, will send a cover letter indicating why they're sending this document. They may enclose a copy of the will. They may indicate that you need to check with your attorney to protect your legal rights. But this lets people know that probate process has started. And you'll see the type of delivery in the middle of this on page 23. It can be personal delivery all the way to first class or registered mail. Most people, it's probably first class mail or just personal delivery because they're all at the funeral and part of the family. But we have many people spread across the country and the world, and we have to give them notice either through the registered mail or first class mail. Just some way we have to give them notice and show the court that we've given them notice. So that's the information to heirs and devosees. Again, that's due 30 days after your appointment. We were over here looking at the application on page 15. Again, this is the first document we bring to the court, along with the will, the death certificate, and then some filing fees that we'll talk about shortly. So this is under 4A. The next time you're at a cocktail party and somebody says you're an heir under the will, remind them you're a devotee under the will. If you're an heir, then you're not taking under a will. You see some questions here about the original will on page 13. Again, a codicil is a way to amend a will without redoing the entire will. And these are just examples. Over on page 12 here, you'll see if you the order of priority for the appointment of the personal representative. Again, it used to be known as executor, executrix, now known as personal representative. I would note under the verification that you sign there that you're submitting to the jurisdiction of the court. So if you're out of state, you're still submitting to the court's jurisdiction here in South Carolina. And we'll look at ways that the order of priority that somebody else can serve if you can't serve as personal representative. The court's going to sign this order of informal probate and informal appointment. And this is done after a review of what you submitted. We would have you sign this qualification and statement of acceptance. And this is a way that you're basically sworn in as a personal representative. Previously, our parents and grandparents may actually remember coming into the court and taking an oath as personal representative to the office. Back then it was called executor, executrix. All right, I always check and see if we've got an honest group here today. When somebody's sworn in and we raise our right hand, we look at the palm of the right hand. Guess what we're looking for? In the olden days, if you're dishonest, they'd take a red hot poker and put a mark in the palm of your right hand, and indicating you're either probably put a T there for a thief or an L for a liar, but they don't do that anymore. But I did have a guy take the stand one time, and he had a mark on the palm of his right hand. I had to ask him about it, and he'd had a construction accident, so you never know. But anyway, that's the anytime you see anybody sworn in, and that's why they raise their right hand. So we come with the application. The other thing that you're going to make a choice on is right here is we'll give you 2 receipts, 1 fee to open the estate and 1 for the publication. Usually 25 or 50 bucks to open the estate, and then a check for the creditor's notice. And here's a sample of the creditor's notice. Again, it has to be a newspaper of general circulation in the county. We've got 4 newspapers here you can choose from. You can see that the prices vary. They're all good notice, and here we're giving notice to creditors. That third part of the interested persons. The first part was devosees, the second part was heirs, and the third part are creditors. And so we're going to publish in the newspaper, newspaper of general circulation, and we'll go over here to page 30, and I'll show you one of the newspaper publications. And this is a typical, this is an affidavit of publication. The newspapers will send this back to it. But what occurs is you choose which newspaper you want to be in. We then batch them together. And at the end of the week, our clerk of courthouse in Atwood will email that over to the newspaper. They'll publish it again. It has to run 3 consecutive weeks. And you'll see the first publication on this one is April the 21st. And so the creditor's period would expire 8 months from the first publication. And the statute of limitations, again, is 8 months from the first publication or 1 year from date of death. You'll see in here, if you can read the little blurb up on the top left, or not top, yeah, left in the column there, that anyone that has a claim against the estate is to deliver it to the court and to you as personal representative. So this is the creditor's notice. Again, think of that concept of giving people notice informally. One was the heirs, the other's devosees, and this is for the creditors. And we'll flip back to, there's a creditor's notice. You make that choice, you write a check, and then we'll make that published. Again, that has to run for 3 weeks, probably a week over, a week back. So it'll be 4 or 5 weeks before we get that affidavit back. We'll put an affidavit in the file and then also send you as personal representative a copy of that affidavit. The fiduciary bond, this is something that has to be posted if you are an intestate estate. Again, it's not applicable in our example because we have a will. The bond is an insurance policy to make sure that you do your job as personal representative. It's calculated 1.5 times the value of the personal property. So this is another reason to have a will. You don't have to post this fiduciary bond. The probate code has great flexibility. You can renounce your right to serve and nominate someone else. You can't skip the alternate, but you can renounce to the alternate or have the alternate sign a renunciation and go to a third person. You can also waive bond. In most cases, if you have a will, bond is not required. Families that where you might have a bond is dad dies, mom is the PR, the kids agree to waive the bond simply because they don't want to incur that administrative cost. Of course, 1 in 10,000 cases, you need that bond. We had a case here where dad had died, mom passed, there's a couple $100,000 in the bank account. There was a brother and a sister. Sister allowed brother to serve. She signed this renunciation and waiver of bond. And lo and behold, the brother ran off with girlfriend and the $200,000 in New York City. And now sister chasing brother. But in most cases, you can waive bond. But if there's someone that is not trusted, then you want to make sure that they post that bond. Once you are appointed as personal representative, you'll get a certificate of appointment. This allows you to take this to the bank or the brokerage firm to show that you hold the title as personal representative of this organization called the estate of. Right, so there's a certificate of appointment. You also will get fiduciary letters. Many times they want both, but one generally will suffice, as indicating that you hold the power and that you have no restrictions in the office of personal representative. We talked earlier about the information to heirs and devosees. Again, that's due 30 days after your appointment. You need to send that out and give the court a proof of delivery. The next document we want to talk about is inventory and appraisement. This is due 90 days after your appointment. We learned about heirs and devosees. Another concept we want to learn about is probate and non-probate property. Probate property is controlled by the will, or if you don't have a will, it's controlled by the intestacy statute. Non-probate property is controlled by a third-party contract. A good example of that is, say, a joint account with right of survivorship, life insurance where you designate a beneficiary. A lot of real estate nowadays is held joint with right of survivorship. Let's walk through each of these. You'll see here on page 27, we've got a recapitulation of non-probate and probate property. Again, you only have to list the probate property, but in the example here, I listed the non-probate property too, just to show you that sometimes the non-probate property can be more valuable than the probate property. Again, probate property is controlled by the will or the intestacy statute if there's not a will. And we just have to list the probate property. We've got supporting schedules for each of these. This document mirrors the Form 706, which is the Internal Revenue Service estate tax return. Estate taxes do not impact many Americans these days. The exemption equivalent is up to 10 million indexed for inflation or $20 million per couple. So it's way up there indexed for inflation. So I'm not going to spend time talking about that. I will talk a little bit when you get into these supporting schedules about another estate tax issue that all Americans can take advantage of, and that's called the step up in basis. And that allows you to get the basis of a piece of property stepped up to the value at your date of death. And let me try to give you an example, and I'll try not to lose everybody or confuse everybody. But if I had bought a piece of property, say 30 years ago for $10,000, and today it's worth $100,000, If I sell it for the 100,000, then I have an income tax gain, capital gains of 90,000. The 100,000 that I sold it for, less what I had originally invested or bought it for, the $10,000. If it goes through my estate, it steps up to the fair market value at my date of death. So that $10,000 property now goes to $100,000 at my date of death if I die today. If my wife sells it tomorrow for the 100,000, she takes that step up in basis, the 100,000. So hopefully you see that example that the one time the federal government is good to you is at death, giving you the step up in basis. And I say that because when you get to the real estate, many times real estate's in a ballpark and you want to go ahead and put it in the higher end of that ballpark. You may incur a few more dollars, $4 or $5 more in probate fee, but you can save thousands of dollars in income tax. Again, consult with your CPA, your tax attorney, your attorney, your accountant to get help in that regard. But I wanted to point out that issue. Again, we have a number of schedules here that we go through. We've got real estate, you'll see listed there, and this is owned in the decedent's name or tenants in common. Tenants in common means that husband and wife or two spouses each own 50%, and they control that 50% at death, either by their will or by the intestacy statute. More and more real estate is held joint with right of survivorship, and we'll get to that schedule, which is over on Schedule E here in a second. But you'll see here, we've got a fair market value listed, and then we've got the value of the decedent's interest. Again, there's no requirement that you get an appraiser on these properties. If you have a taxable estate, then it's very advisable. But you can check with the tax assessor's office. You can ask a real estate agent to give you a letter, or you can go full board and get an appraisal. But there's no requirement in today's probate code that you get an appraiser for any of these assets. Again, real estate, we're listing fair market value and the value of the decedent's interest. Schedule B, we've got stocks and bonds. Generally, you get this right off of the your stockbroker can help you with that, or right out of the newspaper. If it's a closely held business, then you might have to get an appraiser. If it's a privately held business, they would value the underlying assets or the income stream. Schedule C, we've got cash, bank accounts, notes receivable, and you'll see what we've got listed there. Again, this is what's in the individual name of the decedent. And I know you may be emailing in some questions, and I'll try to get those at the end when I run through all of this. Schedule D, remember A, B, and C are all probate assets. Schedule D, life insurance, is generally a non-probate asset. It's controlled by the life insurance contract, and usually you designate an individual beneficiary. There are exceptions, and we'll see under Part 1 here of Schedule D at the bottom of page 26 that we have life insurance where it's designated to the estate, and that would make it a probate asset. But most life insurance would be over here on page 25 at the top, Part 2, where you name a beneficiary. Again, it's not required that you list non-probate assets. Schedule E, another optional schedule, joint with right of survivorship, generally bank accounts or real estate, and then those documents control who receives. I would mention that a lot of our litigation concerns the joint account with right of survivorship. It can be very beneficial in managing money for a senior and helping pay the bills. But if you had a will, like in this case here, if you said you wanted it to go equally to, say, 5 kids, and then you put the local child on the joint account with right of survivorship, by operation of law, that joint account goes to that local child on that joint account that's been paying the bills. If that's what you desire, then that's fine. But if that's not what you desire, then you need to put the local child on the account under the durable power of attorney for financial affairs. That way, because the power of attorney is only good during life, when you pass, then your will would go equally to the 5 kids. Anyway, just something to consider when we look at joint right of survivorship property. And again, almost all real estate is held this way. It used to be that property was tenants in common between spouses, but more and more property is joint right of survivorship. So it passes outside the probate process. Schedule F is other miscellaneous property, just a ballpark figure down here. My old couch that I live on, sleep on, is not as valuable to someone else as it is to me. So you just put a ballpark figure down here. If you have unique assets, then yes, you need to get an appraiser. Or if you have valuation issues. We've got transfers during the decedent's life, Schedule G. You'll see the revocable, the trust down there. Again, that's optional to put that down there. The last page of the inventory and appraisement, page 24, power of appointment, where somebody in their will allows you at your death to name who receives the property. Not that common, but is done in some larger sophisticated estates. Schedule I, we've got annuities and retirement accounts, generally considered a non-probate asset because you name a beneficiary. But it can be a probate asset if you name the estate as your beneficiary, or if the beneficiary named predeceases you. Again, annuities and retirement accounts, these types of things generally are non-probate assets, but they can be probate. Encumbrances, you'll see there. Again, we want to just list encumbrances of assets that we've listed on the inventory. You do not have to list the unsecured claims, such as credit cards. But if you've got a boat loan, a car loan, a loan on the house, then the encumbrances are listed here. Again, that's the inventory and appraisement. It's due 90 days after your appointment. If you look on page 27, you'll see the top here. You can amend the inventory and appraisement at any time and file that. Again, if you later find additional assets, you can amend the inventory and add that. Or if you want to get that step up in basis, we see individuals file amended inventory and appraisement for that. Once that's filed, you get a bill from the court. Again, the fees in South Carolina are relatively small. This is a larger estate. The fees for $100,000 of probate assets is $95. So 100,000 equals $95 in probate fee. And that's why many people, when I do the revocable living trust, it's easier just to do the will with a trust because the probate fees are not substantial in South Carolina. So you get a bill. Once that's paid, we'll show that you get a check from you that it's been paid, and that'll be there. Here was the creditor's notice we mentioned earlier. Again, that's run once a week for 3 consecutive weeks. And the creditor's got 8 months from that first publication to come forward, or 1 year from the date of death is the statute of limitations. This is a typical creditor's claim. It's filed on a pink sheet of paper. It can be any color paper, and any of these forms can be any color, but it's filed with the court. If you're the personal representative, you have a number of ways to handle the claim. Basically 3 ways. One, if it's a valid claim, go ahead and pay it, but you want to pay it probably at the end of the probate process to make sure that you've got enough assets to pay all the potential claimants. 2, you can say it's a valid claim, but the amount's wrong, so you can compromise it. And 3, you could send a notice of disallowance saying it's not a valid claim, the estate does not owe you this money, and you can send a notice of disallowance. What we're looking for from the court is that you've handled the claim. So before you close the estate, you've got to show that you paid the claim, either a check or a receipt, or by sending this notice of disallowance. You send this notice of disallowance, then the claimant has 30 days to come forward. They can have an order for petition for allowance of creditor's claim. That's what it would look like after the hearing. This is a petition for allowance. If you're the creditor, you can file your claim and wait and see if it's allowed, maybe wait for the closing documents, or you can go ahead and petition for allowance. If you're the creditor, you may petition for allowance. The only issue is that you have to pay the $150 filing fee to have your matter heard. So many creditors will wait till the end. This is the deed of distribution, and here's the instructions on this. If you have real estate in the estate, you have to file a deed where you give up your interest as the personal representative and deed it out to the individuals to take under the will or by the intestacy statute. The deed is filed at the Register of Deeds office. You give it to us and we can run it over there, or it's filed there. And it takes a couple of weeks to get back. And then it's put in your probate file. The deed of distribution, you should execute this after the creditor's period is run to make sure that you don't have any claims out there that you may need to have the real estate. So once you file this deed, then you're giving up your right to the property. And of course, the deed looks like this. You need to consult your attorney or do it yourself. I would recommend consulting your attorney to help you with the deed of distribution. But it is a deed. Our state clerks are very talented, but it's considered practicing law, so that's why they can't help you with this. They're not lawyers, so they cannot help you with the deed of distribution, even though many of them have 30 plus years experience. Again, there's the instructions for the deed of distribution. If you are a sole heir, sole devotee, you do have this benefit of closing the estate through a verified statement. So instead of having, say, the 4 kids involved here, if mom was, I guess, the only taker or the only surviving individual, she could sign this verified statement to close the estate. If everything was going to her, indicating that she's done everything she's supposed to do and that she is the taker under the estate and the creditors have been paid. But most estates will have these other documents, what we call closing documents. It starts with an application. I'll show you the application for settlement, where you basically say, I'm ready to close the estate and I've attached these different documents, or I've done these different functions here. And with the application, you would do a waiver of, I'll do the waiver, come to this, notice of right to demand a hearing. So what you're going to do is send the application out, and then you're going to have this notice of right to demand a hearing. So basically you're saying, I've done my job as personal representative. Here's the accounting, the proposal for distribution. Here are some receipts. If you have any objection, then you have 30 days to come forward. Most estates, there's not an objection. The clerk diaries it and then closes the estate 30 days after that, after this notice of right to demand a hearing goes out. If you can get all the family to waive the statutory filing requirements, then they can sign this waiver. In many cases they do, the family's close and they know there's no issues. But if you want to see the closing documents, don't sign the waiver of statutory filing requirements. This is a receipt and release with waiver. If you give any property to an individual, you want them to sign a receipt. Many will not sign the release part because it indicates that they have no liability or recourse against the personal representative. They may want to see the closing documents, in which case you would just sign a receipt and then also be able to see the closing documents. Because in this one over here, you say, in consideration above, the undersigned hereby releases and forever discharges the PR. That's that waiver part that you may have concerns with. And proposal for distribution, here's an example of it. You haven't distributed an asset, this is what you plan on doing. And the accounting, this is what we started with, some money, and this is our receipts, and this is how I plan to disperse it. You'd give the detail on the page behind it, which shows how you plan to disperse the property or the assets or the cash in this case. Again, these are the closing documents. They're sent out with that application, and you let people know that you've done that. We come over here and we're going to send a proof of delivery. So here's mom as personal representative giving notice. Notice here, it's only 2 of the kids, the 2 that took under the will. They're giving notice of the closing documents, the final accounting, proposal for distribution, application for settlement, and that notice of right to demand a hearing. If they don't object, then it's closed 30 days afterwards. And you'd get an order closing the estate and a certificate of discharge. Again, that's very quickly. the probate process, normal administration. Let me mention a few other things, and I'll see if I can open it up to some questions. Again, here's the index. If you close the estate and then you later find additional assets, you can do what's called subsequent administration to probate those additional assets. Maybe you find a stock certificate up in the attic and didn't realize you had it. You can reopen the estate. It does not reopen the creditors period. And so you can do a little mini probate after the estate's closed, and there's documents for that subsequent administration. The fee to reopen, I don't know how they came up with it, but it's $22.50. And that's how you reopen the estate. The other thing, if you get behind on any of these statutory requirements, remember, you got 30 days to send out the information to heirs and devosees, 90 days to file that inventory and appraisement. If you get behind, you can simply ask for an extension of time. We've got forms for that, or you can send us an email. We just need something in writing that you need additional time to probate the estate. Let me see what else. And let me see if I can find the questions. I'll see if my law clerk is listening and comes in. Let me see what I've got here. The questions. I'll leave this up. Let's see what we got. Here comes my expertise. Any questions? Some questions are in chat. Let me see if I can find those. And we get a copy of this webinar. I'm not sure if I recorded this one. I'm not sure if I did. We did. We can get you a copy of it. Of course, it'll be the same charge, which is free. It's my joke. Let me see if I can answer these questions. Where can I go to the front of these questions here? Let me look to the first one. One question is a payable on death or transfer on death? Let me ask my law clerk to stay here just for a second. That's another way of using basically a joint account to transfer property. It's just like anything you can, if I'm driving to a certain spot, you can take a number of different routes. The same can be true of estate planning. You can use probate and or non-probate transfers many times to accomplish the same goal. Let's see what else I've got here. Somebody indicates they've got a 5-year-old trust. You'd like to update. Do I need to rewrite or can I modify it? I would have you get with your attorney and have them look at it. They may be able to modify it, or they may recommend an entire new trust. Let me see what else we got. If you've got any suggestions on how to make this better, this is our first time, so we're all ears. One is question, is the PR limited on what they can charge the estate? Generally, you first look at the will, and when you do your estate planning, you want to go ahead and indicate how the personal representative would be compensated. The statute provides 5%, if you don't indicate, up to 5% of the personal estate. Does not include the real estate unless the real estate is sold. That may or may not be fair. 5%, if you had a $10 million estate in one bank account, it'd be nice to get 5% of that. That may not be fair where somebody had 10 rental properties with college students in there, and you had to answer all those questions, and you only got 5% of the rental income. So it's the PR. If they do additional work, they can petition the court for additional compensation. But generally, we look to the will. If not, the state statute says 5% of the personal estate, not including the real estate unless the real estate is sold. Another question is, if we have properties in other states, do we have to file documents in that other state? Generally, yes. You do what's called an ancillary probate. You take the documents here, such as the will, the inventory, and then we send those over. And it's basically a certification that we send over. I think the fee is like $20, and it allows that local, state, and county to see that a probate has been done and how the property is transferred. But our state clerks can help you with that. Let's see if we got other questions. I'm not sure if I'm seeing them all. Let me get my law clerk to see if we can't slide down, see if I'm getting them all. Look. Yeah, one here. The principal and a durable power of attorney is the, say like for myself, I name my wife as my agent under the power of attorney. I would be the principal and she would be the agent. And the principal does the work if I become incapacitated, then the agent does the work for me. The principal is the person setting it up. Do you need a revocable living trust with a will? Generally, if you have a will, have a trust inside that will called a testamentary trust. You don't necessarily need the revocable trust. But if you do the revocable living trust, then you need a pour over will. As far as designating a person or life insurance, it's better to designate the beneficiary or a trust or a person. I would have you sit down with your attorney and see what your goals are as far as that life insurance. You generally, if it's a spouse, the spouse wants it outright. So the other questions here. Oh, good question. Should timeshares in other states be probated? And generally, you have to look at the contract with timeshares. In fact, that's what started everything here with the joint with rider survivorship for real estate up in Myrtle Beach with all the different properties being owned. But generally, you have to look at the timeshare contract. But I believe it is ownership in real estate, so I think it has to be probated. But I'd look at the timeshare agreement. Let's see what other questions. And I know you're all free to go. We've had a bunch that have stayed on a long time. I'll probably try to leave you with one last. Let me see if I can get you to smile. Let me see if my law clerk has any good jokes. We did have a family, well, we used to recognize common law spouse here in South Carolina. We had two ladies trying to claim a man's body. The man had no assets, but they both wanted his body. And I had a funeral home on the phone. And I said, we have to use the biblical analogy. And what did King Solomon say? But cut the body in half. He didn't laugh. I said I was just kidding. And they both loved the man. And so what they did is they had one service one afternoon and one the next morning. So let me see what other questions we have. We got some others. How long can a court keep delaying the hearings? We generally don't try to delay anything. In fact, if you have an emergency now, we'll do it now. We've had emergency hearings while we've been shut down. We've done one here in court with social distancing. We're continuing all of our commitment hearings online, and we can do even some of those now online. Let's see what's out. Living trust situation, how is the basis for any real estate determined? It's whatever you purchased it for, and then it would go up in value at your death. We'd get a step up in basis. I'm asking my law clerk to confirm that, but I think he's shaking his head yes. I hope this has been helpful today, and we'll try to get better at it next time. And if you know of other organizations that want to hear from us, we're here to help others. The main thing is to do your estate planning. Remember to take that ski vacation, and we're here to help you with the probate process. And enjoy your day. Goodbye.